Page 166, continued para. Since the first land grants were made to priests and temples who continued to receive the majority of these throughout our period, most grants to officials and vassals faithfully followed the religious form and even repeated the imprecatory verses. The religious draft could well be used for those brahmanas who held civil and military offices, for because of their hereditary religious position, they were entitled to gifts in their own right. But in the grants to non-Brahmana vassals and the officials, the prevailing form had to be adopted for want of an alternative. Gradually there evolved a form of draft for secular grants, slowly deviating from its religious prototype. Thus, in a grant to a Kayastha minister in Orissa about the beginning of the 11th century, the clause of perpetual endowment is left out. 188. Although the provisions relating to the enjoyment of all rights in the village and the spiritual merit accruing to the donor are retained. This also applies to a few grants made by the Chandelas to Rautas, R-A-U-T-A-S. 189. A Chandela grant made to a hereditary Brahmana, Rauta, also omits the clause of perpetual tenure. 190. But this provision is retained in a Silahara charter of 1115, according to which Gandhara Ditya assigned 2 villages to his vassal, Samanta Nolamba, to be enjoyed by his descendants as long as the sun and moon last. 191. Although he did not speak of religious merit in this context. However, no epigraphic land grant is couched in an entirely secular form. This terminology, briefly provided in the law books of the Gupta period, is elaborated in the Lekha Paddhati, which dispenses with religious formulae in its specimens of grants by Rajas, Mahamatyas and Ranakas. The exact epigraphic duplicates of these charters, Pattalas, have not yet been discovered, although it is definite that these were granted by the Chalukya rulers. The origin of the term Pattala is obscure, but if it is taken as an early form of the Hindi word Pattal, Gujarati Patal, page 167, it would imply provision for food or maintenance. The Chandela grants of the 13th century use the term prasadena pradatta, bestowed by the favor of the king. 192. The grants of Western India of the 12th and 13th centuries use the phrase Prabhu Prasad Abhapta, AVAPTA, acquired through the favor of the Lord. 193. Such wordings do not characterize grants to gods and priests and indicate that in legal terms the beneficiary did not owe the grant to his services or ability but to the favor and goodwill of the master. Curiously enough, none of the secular grants clearly states the obligations of the beneficiaries, which are laid down only by the Lekha Paddhati. Therefore, for the country as a whole, there did not exist any legal norm to which the parties could appeal in case of dispute or violation of agreements entered between the two. Para. The didactic texts generally do not impose any obligations either on the Samantas or on their lords. Political experience was hardly embodied in ideology. The only theoretical text which seems to define the duties of the vassals is the Agni Purana, a work of about the 10th, 11th century, and what it states is mainly based on the Kamandaka Nitisara, ascribed to the 8th century AD. The Samantas are advised to assuage public feeling to help their overlord in war, to mobilize the overlord's allies and auxiliaries, and to distinguish friends from enemies. They are further asked to protect the people, Janatranam, like a fort, 194, a function that devolved on them from their sovereign. On the other hand, the king is advised to be on his guard against the vassals whose revolt is considered to be an external danger in contrast to the internal danger caused by the disaffection of princes, ministers and other high functionaries. 195. The Agni Purana therefore instructs the king to destroy disloyal feudatories. 196. But hardly any other didactic text of the period prescribes the mutual obligations of the sovereign and vassals. Para. The only legal text which clearly defines the obligations of the fief holders is the Lekha Paddhati, which reflects conditions in Gujarat in the 12th-13th centuries. This text refers to three kinds of charters written on the bark of the birch tree. A. The charter of a king, Rajne Bhurja Patala, who could grant a Ranaka, a country, within bracket Desha, probably a mandala under the Chalukyas, page 168, excluding the grants made to temples and brahmanas, 197. B. The charter of a Mahamatya Patala issued to a Ranaka who accepted it and undertook to pay all dues to the grantor loyally and honestly, 198. And C. Finally, the charter of a Ranaka Patala. The last deserves special attention, for it provides us details which are not found under the first two heads. In this case, a Rajaputra applies to the Ranaka for a fief. When he is granted a village, he is required not only to maintain law and order in it and collect revenues according to old just practices, but also to furnish 100 foot soldiers and 20 cavalry for the service of the Ranaka at his headquarters, 199. What is further important is that he acquires some sort of right over the land granted to him. This can be inferred from one of his obligations, which does not allow him to make gifts of uncultivated land to temples and brahmanas. 200. This may imply that he is authorized to make grants only of cultivated land in the village. This clause therefore reverses the old practice sanctioned by the Bhumichhidranyaya, according to which at first only waste land was granted to priests and temples, although from the 5th century onwards this technical term continued to be used even in grants of cultivated land, page 2, footnote 201. The insertion of the above provision would suggest that by the end of the 12th century, in Gujarat, the progressive role of land grants in opening West land to cultivation had practically come to an end. Para. The contracts given in the Lekha Paddhati are important because they clearly state the obligations of the parties, so difficult to infer from the inscriptions. This is not done in the first Patala, but the second, and especially the third, indicate a full-fledged feudal polity in Gujarat. They clearly show that the king or his Mahamatya, these two together are invariably referred to in 12th and 13th century Chalukya epigraphic grants made by vassals, granted fiefs to Ranakas and the sub-infeuded land to the Rajaputras. Para. In their turn, the Rajaputras, as we learn from the forms of contracts for the collection of the village revenues, Grama Pattakas, farmed out their villages to merchants and their associates who applied to them for the purpose. 202. Page 169. According to one document, the Panchakula, led by a merchant or accountant, Mahantaka, is entrusted with the work of collection on condition of paying 3,000 drachmas as the main head of revenue, 216 drachmas for rewards to the Panchakula, and 40 drachmas for miscellaneous expenses, 203. The main revenue is to be paid in 3 installments, 204. In addition to the stipulated amount, the merchant and his associates are required to pay any increased rent, a tax imposed on the village for honoring a particular man, a tax on villagers on the birth of a prince to the royal or chief's family, and similar other occasions, and charges for a police station. 205. The village collectors are also charged with the responsibility of safeguarding the roads that pass through the village. The contract has to be accompanied by a guarantee given by another Rajaputra who undertakes to make the merchant and his associates pay. 206. The document which gives these details is dated 745, but there is no doubt that it throws light on the revenue system in the 12th-13th centuries. The practice of Grama Pataka shows that many Rajaputras held more than one village from which they could not collect taxes themselves, and hence, having made the assessment in terms of cash, they entrusted the collection to merchants who, because of thriving trade and commerce in Gujarat, were in a position to accept their responsibility. They were not revenue farmers making the highest bid, but agents bound by the amount agreed upon in the contract. The real master of the village was the Rajaputra, who could not only grant land but also increase taxes and farm them out to whomsoever he liked. Para. The Grama Patakas were apparently valid for a year, but there is no indication of any time limit in the charters granted by Rajas, Mahamatyas and Ranakas. Perhaps they lasted for life or during good behavior, and presumably had to be renewed on the death of either party. It is not clear whether in case of a dispute between the Ranaka and his vassal Rajaputra, the king intervened. Since these agreements were written on the birch bark, none have come to light, but there is no reason to doubt their authenticity. Para. By and large, the relation between the lord and the vassal, page 170, seems to have been regulated by custom which was not clearly defined anywhere before about the 13th century. In the earlier period, when kingdoms were larger, the lord could take advantage of the absence of written law to exact more obligations than were customary from the vassals, but in the period under review it would work the other way. The vassal could exploit the situation in his favor, for there could be no better condition for asserting his power than the presence of numerous kingdoms in northern India on the eve of the Turkish conquest. Para. The theoretical position that vassals and high functionaries should be remunerated by grants of land came to be well recognized in the 12th century. Earlier texts expatiate on the merits of grants of villages for religious purposes, but do not recommend large-scale grants for secular purposes, which is unequivocally done by the Manasollasa a work of the 12th century. It advises the king to make various kinds of gifts, including those of territories, to leading vassals, Samanta Manyakas, and various grades of ministers, 207, such as Mantrins, Amatyas, and Sachivas. Gifts should be also made to servants, Vrityas, kinsmen, Bandhavas, and other people who render military help to the king and tender him counsel, 208. Altogether, 16 kinds of secular gifts are listed, and they include not only distribution of villages, towns, mines, and marks of honor comprising seats, chamara, umbrella, and means of conveyance, but also that of virgin girls and prostitutes, 209. Of the land assignments mentioned herein are Deshyam, Desyam, the gift of a subdivision, Rashtra, presumably exempt from taxes, Karajam, a similar gift with the obligation to pay taxes, 210, and Gramajam, the gift of a village with or without taxes, 211 para. The practice of making land grants had become almost universal in Malwa and Gujarat. This is reflected in a chapter of the Prabandha Chintamani of Merutunga dealing with the Paramara Bhoja and the Chalukya Bhima. He states that the lord of the country gives away a village, the lord of the village a field, and the lord of the field some vegetables. Every contented person gives away his property, 212. This would imply that ownership of the village by individuals had come to be recognized as a normal feature by 1304, when Merutunga completed his work, page 171. Many of these Gramadhishas may have been Jain and Brahmana temples and individuals, but others may have been just vassals or officials who were granted villages by the Paramar and Chalukya rulers. In some cases, the Pattakilas, 213, who were so designated because they received charters, pattas, for revenue collection from the king, may have developed into village lords, with the difference that they had to forward a portion of the revenues collected to the central treasury. Para. In spite of numerous references to the term Samanta and its various formations and synonyms, the earlier texts do not provide any ideological basis for political feudalism, which shows that it had not taken any deep roots in the consciousness of the people before the 11th century AD. Even the legal commentaries do not betray awareness of the new development, for the Mitakshara continues to use the term Samanta in the traditional sense of neighbor. Surprisingly enough, the theoretical basis of political feudalism is found in the text on art and architecture. An integrated theoretical picture of feudal hierarchy is provided by the Manasara, a work of about the 12th century. Chapter 42 of this text classifies kings in descending order of status into 9 classes. Chakravartin, Maharaja or Adhiraja, Mahendra or Narendra, Parshnika, Parsnika, Pattadhava, Mandalesha, Pattabhaj, Praharaka, and Astragrahin, 214. The number of their horses, elephants, soldiers, women, and queens is prescribed accordingly. The Astragrahin, the lowest in rank, is entitled to have 500 horses, 500 elephants, 50,000 soldiers, 500 women attendants, and 1 queen, 215. This equipment goes on multiplying with increase in rank till it reaches the highest figure in the case of the Chakravartin or universal monarch 216. The Manasara also describes 9 kinds of crowns and 9 kinds of thrones according to the difference in status of the rulers 217. What is most important for our purpose is the differing rate of royal revenue according to the position of the king. The Chakravartin takes only 1/10 of the produce as his share. The Maharaja takes 1/6, the Narendra 1/5, the Parsnika 1/4, and the Pattadhara 1/3, 218. The exact rates of the other 4 kinds of rulers, Mandalesha, Pattabhaj, Praharaka, and Astragrahin, are not given, but the context would make it half and even more than half of the produce. 172. Page 172. What is the significance of this type of formulation? In our opinion, the whole scheme visualizes a state of affairs in which the ruler of a lower rank is in a position where he has to pay tribute to the ruler of a higher rank. Only in this context can we understand a system in which the lower the royal rank, the higher the revenue to be extracted by its holder from the subjects. Para. Similarly, the Aparajita Pracha of Bhatta Bhuvanadeva, a work of the 12th century, 219, enumerates in descending order 9 categories of rulers known as Mahipati, Raja, Naradhipa, Mahamandaleshwara, Mandalika, Mahasamanta, Samanta, Laghu Samanta, and Chaturasika. 220. In each case, the extent of territory held is specified, and it ranges from the whole earth in respect of the Mahipati and 1,000 villages in respect of the Chaturasika. 221. The lowest category is not given any nomenclature, but apparently the holders of villages from 1 to 20 and probably 100 are placed in this class. 222. Although the division of rulers laid down in the 2 texts on architecture does not seem to have been observed, this framework fits in with the feudalization of political structure in medieval times, which provides many instances of graded subordinate relations linked up with tribute and service. Para. The Aparajita Pracha also describes the composition of a typical feudal court. It recommends that the emperor, Samrat, who holds the title of Maharajadhiraja Parameshwara, should have in his court 4 Mandaleshas, 12 Mandalikas, 16 Mahasamantas, 32 Samantas, 160 Laghu Samantas, and 400 Chaturasikas. 223. Below whom all the others were known as Rajaputras. 224. It further lays down that the income of the Laghu Samanta should amount to 5,000, of the Samanta to 10,000, and of the Mahasamanta to 20,000, a scheme also supported by a 14th century work on architecture, the Raja Ballava Mandana. 225. The text, however, does not fix the rate of revenue to be collected by those chiefs from their subjects, but it does provide a systematized hierarchy in terms of political and economic power. Para. Early legal and other texts conceive differences in political power, income, houses, resources, etc. in terms of varnas only, but the position changes in the works on architecture. Privileges are no longer assigned to the people exclusively according to their hereditary varna. Page 173. On the other hand, an attempt is made to reconcile the status based on Varna with that based on feudal hierarchy. This is noticeable in a few passages on architecture in the Brihat Samhita of Varaha Mihira and in the Maya Mata. Varaha Mihira speaks of the size of the houses of the various categories of ruling chief and also of the four Varnas. The Maya Mata lays down that the king of the whole earth should have a 11-storied house, the Brahmanas Dvijati, a 9-storied house, Nabhavumi, the ordinary kings Nripas, a 7-storied house, the Vaishyas and ordinary captains, Yodha Senesha, a 4-storied house, the Shudras, a house ranging from 1 to 3 stories, and the Samanta Pramukhas, a 5-storied house, Panchabhumakam, 2 to 6. Here, different categories of kings and samantas are introduced in the housing scheme more clearly than is done by Varaha Mihira. The Aparajita Pricha, however, does not take account of Varna in prescribing the size of the house, which is determined by the relative status of the feudal elements. It clearly lays down the size of residence of each one of the 9 categories of chiefs, including Mahamandaleshwara, Mandalika, Mahasamanta, Samanta and Laghu Samanta, and of some others who are lower in the scale, 2 to 7. But the use of a Simha Dwara is permitted only to the Chakravartin, Mahamandaleshwara, Mahasamanta and Samanta, and not to those lower in rank, 2 to 8. According to the Manasara, members of all 4 castes can become Praharakas and Astragrahins, the last 2 categories of rulers, and their privileges vary according to the rank. Thus, by transcending considerations of Varna, these texts provide a basis for the emerging social and political organization which can no longer be ignored. Para. At the end of this chapter, we may review the existence in northern India of numerous principalities, many of which owed their origin to the widespread practice of land grants or the partition of ancestral dominions among the princes of the ruling family. Of course, direct records of grants for military and administrative service are not as many as those of grants to priests and temples. In fact, many records which give a clue to assignments to officials and vassals are actually religious grants, page 174, made by these dignitaries. In India, we do not notice any counterpart of the struggle between the papacy and the state, which characterized the history of medieval Europe. While in the middle of the 9th century, the Carolingians confiscated the property of the church and granted it to their secular vassals, 2 to 9. In India, whatever the complexion and nature of the ruling dynasties, they vied with one another in making religious grants. Religious and secular vassals grew at the cost of the regular officials, who themselves acquired a similar status because of their payment in land grants. Of course, conditions in eastern India were different from those in Gujarat and Rajasthan, where the relation between the lord and his vassal was governed by contracts. The comparative absence of secular copperplate charters under the Palas and Senas suggests that ordinarily royal servants and feudal lords were not allowed to become powerful enough to claim a lasting basis for their grants, as was the case under the Chalukyas, Parmaras, Chehmanas, Gadavalas, Chandelas, and the rulers of Orissa, Para. The period also bears witness to the growing practice of earmarking dues for officials in Baghelkhan, Bundelkhand, Uttar Pradesh, and Rajasthan. The custom continued under Muslim rule, for Shesha reserved certain dues for the payment of his collectors. Finally, by this time, the feudal system was so well established that it came to be reflected in the Sanskrit texts, which was slow and conservative in recognizing changes that did not fit in with the fourfold social order outlined in the Dharmashastras. The Manasollasa, the Lekha Paddhati, and several texts on art and architecture give a picture of the feudal pyramid which is not found in the earlier works. Some texts of the period boldly recommend gifts of land for secular purposes, and others clearly lay down the obligations of the secular beneficiaries. All these factors provided a congenial climate for the introduction of the fief system by the sultans of Delhi. Next, notes and references.